In a dramatic and history-making 2.5 hours on the floor of the Supreme Court earlier today, the questions justices chose to ask about former President Trump's claim of absolute immunity could give us a window into their thinking. One justice, Amy Coney Barrett, was appointed by Donald Trump, of course, to the bench, appeared to express cynicism about the legal argument that a president cannot be convicted in criminal court if he was never impeached first and convicted of that impeachment by the Senate.
Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase in the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so? What if the criminal conduct isn't discovered until after the president is out of office, so there was no opportunity for impeachment?
Joining us now is MSNBC Supreme Court contributor Jennifer Mascott, an assistant law professor at George Mason University and a former law clerk for both Justice Clarence Thomas and for then Judge Brett Kavanaugh before he joined the High Court when he was on the appeals court. Jennifer, good to see you again. What do you make of Justice Amy Coney Barrett's line of questioning? She seemed rather skeptical of that impeachment first, and conviction on impeachment, I should say, before anyone could be prosecuted for private acts, let's say, not official acts.
Well, great to see you, Andrea. You're correct. There was really an extraordinary set of oral arguments today at the Supreme Court. And these questions raised by Justice Barrett and others of criminal prosecution of a former president really raised some core questions about the future role of the office of the presidency. And you could tell that a number of the justices, some of whom have served previously in the executive branch, have some questions and concerns about this idea that the role of federal prosecution might potentially be used as a weapon against prosecution of former political rivals, or here, in this case, actually, President Biden's Department of Justice is prosecuting a current rival. And so I think some questions like Justice Barrett's are going to end up perhaps not being central maybe to how the court decides to resolve this case, because I would expect that some questions that extend far beyond the scope of the particular facts here might motivate the scope of the decision that the court eventually hands down.
Jennifer, it's Chris Jansing. With Justice Barrett, Trump's lawyer, Mr. Sauer, admitted that some of the allegations in the indictment were examples of Trump acting in a private role, not in an official capacity as president. And we've talked a lot about that distinction. But he claimed that other charges were presidential acts, like those accusing Trump of meeting with Justice Department officials or lobbying members of Congress. I wonder if you read that as a kind of fallback plan by Sauer in having some, but not all, of the charges Trump is facing may be dismissed from the indictment.
Well, that's a great question, and you're exactly right that the justices seem really focused on this question of what is an official act versus an unofficial act. I think the challenge that the prosecution is going to have here is that the justices, particularly those who understand how offices like special counsel or independent counsel sometimes have been used broadly in the past, like in the case of the impeachment of President Bill Clinton and Ken Starr, that they're going to be worried about too narrowly drawing the line of official act, and it's possible that they will draw that broadly enough that even if it goes back down to the district court, it could be very hard to prosecute these particular charges and allegations against President Trump without getting into very challenging fact issues and create so much delay that, in a sense, the prosecution here is really made a lot less effective, and it ends up being a huge victory for the former president.
And Jennifer, I want to ask you just very quickly about Justice Kavanaugh's comments and some of the other judges, certainly Justice Alito, concerned that former presidents could face malicious prosecutors or attorneys general. There was talk about the decades of special counsels, and now that law ended in 1999, I think. So that's a different case. But they were arguing that if a former president can be prosecuted at all, that they could be, penalized in a close election, that their opponents, if they are elected, if they're defeated, could come after them. And it was kind of turning things on its head. But it's also that, as you know, with Justice Kavanaugh, you clerked for him when he was a judge, was previously worked for Ken Starr, one of the more controversial of the special counsels under Bill Clinton. What do you think of all that?
Well, you bring up an extraordinarily interesting and I thought actually quite fascinating part of the oral argument. I want to first be clear that I think everybody on both sides agrees that if something is purely a private act, that it is definitely the case that even former presidents, everybody's subject to the law. You can't engage in private criminal conduct. The question here is who's in charge of deciding what makes something an official act. And I think the question is that when it's the special counsel, or as you're right, this is sort of a watered down, Jack Smith has a watered down version of the office that Ken Starr used to have. And you're indeed correct that Justice Kavanaugh previously worked for Ken Starr in that Clinton prosecution, and I think is aware firsthand, as are many folks who have served in both Republican and Democrat administrations, about how investigations, when they get started and are not really subject to close supervision, can just, even for the purest of motives, somehow take on a life of their own. And I think the justices are going to be really concerned to reach a decision here that further emboldens this office. And this might actually turn out to be a case where strategically, by bringing this prosecution, Jack Smith inadvertently ends up weakening the office of the special counsel for years to come.
Jennifer, it's Katie Tur. I'm so happy you're here. I'm curious. I mean, you've clerked for Justice Thomas. You clerked for Judge Kavanaugh. Was there anything in their line of questioning today that signaled to you which way they're leaning?
You know, I think for both of their judicial careers, they have definitely been concerned about, as are most of the justices, I think all of the justices really, regardless of their perspective, are concerned about figuring out what is the proper role of each of the institutions of government. And I think the justices are going to be really concerned about inadvertently reaching a decision or permitting prosecution in the courts that's perceived as weakening the function of the executive branch. And Justice Kavanaugh actually, even in his confirmation hearings, talked a lot about Morrison versus Olson, a decision that found that the independent counsel, the office Ken Starr held, was constitutional. And Justice Kavanaugh has since before taking office in the Supreme Court been expressing grave concerns about that decision. And he mentioned it again today. And I think that'll really motivate a lot of the justices' thinking and how this case comes down.
Jennifer Mascott, thank you so much.